Hey guys, in this video, we're going to talk about the 2 ways that the government can go after a naturalized citizen. Again, there are nearly 25 million naturalized Americans, and some of you are worried about losing your citizenship under this new administration. I'm doing a new series on denaturalization to help you to understand how this process works and certainly whether or not you have anything to be concerned about. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in immigration freedom. Type in freedom now and certainly reach out to us if you have an immigration problem that you'd like us to discuss with you. If you have not yet watched part 1 in this series, watch that video so that you could get more information about this process. The first way that the government can go after an individual to denaturalize or to strip them of their citizenship is if that person procured naturalization by concealing a material fact or by willful misrepresentation. Now, what does that mean? It means that if during your naturalization process, it could have been 10 years ago, 5 years ago, or 15 years ago, or longer, if during that process you lied on your N-400 application or you lied during the interview, the government will consider it to be material or willful misrepresentation. Or perhaps you decided that you were just not going to share some important information during that naturalization process. You concealed something that was important. You withheld it. So for example, if you were a member of a group that the government considers to be a terrorist group or a threat to the United States, yet you concealed it and did not include that information on your application, well, that is concealment, and that is a ground to denaturalize an individual. Failing to disclose very important facts to the government during naturalization is all they need to start that process against an individual. As discussed in my first video, they could proceed with a civil process, guys, of denaturalization, which doesn't have a statute of limitations of 10 years on it. So if you had applied for naturalization and concealed this really important fact 15 years ago or even 20 years ago, and they now discover this, well, they could open up a denaturalization proceeding against you. Now, the government will have the high burden of proving these 4 things. Number 1, you misrepresented or concealed some fact. Number 2, the misrepresentation or concealment was willful. Number 3, the misrepresented or concealed fact or facts were material. And fourthly, you procured citizenship as a result of the misrepresentation or concealment. All 4 of those elements must be proven. And if they fail to prove one of those elements, well, they will not be successful with denaturalizing an individual. Now, the conduct that the government is looking at certainly is around the time when you applied for naturalization. That's really that point in time that they're honing in on to say, gotcha. So how does this work practically? I've given other examples in my other denaturalization videos about individuals who committed a crime, and the government was able to strip them of their naturalization. So the facts typically look something like this. A person committed a crime before they naturalized, before they applied for naturalization, and they were never arrested for that crime. They moved on with their life, applied for naturalization. During that naturalization application process, they say no to the important question about whether they had ever committed an offense for which they were never arrested for. Then they go on the interview and they say no again to that very same question, and they become a citizen. Years later, something happens. There's a trigger on the criminal side usually, and during that criminal prosecution of whatever the issue is, it becomes clear to the government that during naturalization, that person actually concealed a very important material material fact that he or she had committed a crime for which they've said no to during the naturalization process. And that alone is ground to now either to get them on the criminal side for naturalization fraud, which comes with 10 years imprisonment, or on the civil denaturalization side, if they had been a naturalized citizen for 10 years or longer. So that's how it typically happens. Sometimes the USCIS will make the referral to the Department of Justice, and the U.S. Attorney's Office will pick it up and take it further to strip that person of citizenship, or the U.S. Attorney's Office is already going through a criminal matter with this individual and looks at their immigration status to determine whether they had also committed naturalization fraud and see whether they could strip that individual of naturalization as well. So the conduct here is pre-naturalization. However, there is a way for them to go after a person for conduct that happened after they naturalized. The federal government may choose to denaturalize an individual if he or she is or becomes a member or affiliated with a communist party, another totalitarian party, or a terrorist organization within 10 years immediately preceding or before the filing of naturalization, or the 5 years immediately following naturalization. So for instance, if a person becomes a naturalized citizen and then within 5 years of being a naturalized citizen, they are now affiliated with a terrorist organization or a new terrorist organization that our government has now said is a terrorist organization, well, the government now has grounds to go after that individual for being affiliated with this terrorist organization, and that's how they could get that individual. The second ground for denaturalization is the illegal procurement of naturalization. And to put it plainly, this happens when an individual is not eligible to naturalize in the first place. They did not meet one of the core requirements for naturalization, such as the requirements for continuous residence, physical presence, lawful admission for permanent residence, good moral character, or attachment to the U.S. Constitution. Friends, I'm studying the history of citizenship and reading this terrific book, You Are Not American, Citizenship Stripping from Dred Scott to the Dreamers by Professor Amanda Frost. And in it, she says that, historically speaking, for naturalized citizens in particular, the government's citizenship stripping campaigns forced them to live in fear, chilling any inclination to speak out against the government or the norms of mainstream America. Even decades after becoming citizens, the government could decide that their words, actions, or beliefs suggested that their oath of allegiance to the United States had been a lie, serving as the basis for denaturalization and expulsion. This is really important, friends, because when you're talking about an attachment to the U.S. Constitution, remember that oath that you had to take during your ceremony, which said that you pledged, obviously, your allegiance to the United States and to our Constitution by your words and or your actions. Could the government call into question your allegiance and attachment to the Constitution as a basis to seek denaturalization? That's very well possible. Friends, there's a lot more to say about denaturalization. Watch my series on it. If you're enjoying this video and series, do me the favor and subscribe to my channel and hit that notification bell so that you'll be the first to get notice of my videos each week. Thanks so much for watching. Comment below and I will see you in the next one. Bye-bye.